From distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey, yo, folks! Hey, how are you all doing this Monday, the 24th of March, March 24th? And to my recollection, the 24th, something in a prior docket, we heard about, oh, we will have this person back on the 24th. And to my recollection, it was amazing. I just can't remember who or why. Just, this will be amazing. So I said I will go back on the 24th and let's see what happens. So, Judge Stephanie Boyd in Texas, 187th district. It's her docket day. Some will be there, some will be on Zoom. I checked beforehand. The microphones work. So today we will actually hear what is going on with the defense attorneys and the prosecutors and the people charged. So I will not promise today will be anything interesting, but so far there's at least one good case where somebody, hey, I'm doing fine, or the opposite. Let's see who is here now. Slidey Pie over at Rumble. I see Aaron. I see Gigi. I see SB. I see Gwendolyn. I see and the Wars and a bunch more. And hello, you guys over at X. And for you who missed the guy, here is Mr. Jingles. Mr. Jingles, of course, is the actual owner of this channel. Everything here is by his approval, just so you know. But we are here for this. I like her. I like her a lot. And so we just have to see what is going on in Judge Boyd's courtroom today. Dun, dun, dun.
All right, when I call your name, you need to stand and let me know that you are here. Otherwise, I'm going to assume you're not and a warrant may be issued for your arrest. Kavanta Thomas. Randy Folsom, custody. Tony Medellin, custody. Mary Guerrera. Mary Stella Guerrero. Brian Pina. Josephine Marquin. Daniel Chapa, custody. Teresa Frias.
Yes, Your Honor. President, on her behalf, if I may be afforded the opportunity to give her a call, I can advise her.
Thank you. Daniel Montoya, custody. Robert Stevens, Robert Dale Stevens. Thank you. Jeffrey Guerrero, Jorge De Leon, custody. Vanessa Portales. Aaron Joseph Mendez Trevino.
Yeah.
Thank you. Juan Aguilar. Lorenzo Garcia IV. Albert Hernandez, custody.
I remember the name the Fourth. I don't know why. I also remember the name Aguilar. I don't know if it is the same. We'll just have to wait and see.
Jaime Antonio Escobedo. Jaime Escobedo or Jamie Escobedo. Jose Romero, custody. Mary Ballinger, custody. Oscar Jimenez, Courtney Flores, Richard Vance, custody. Maria Villarreal. Thank you. John Philip McCarter. All right, thank you. Christopher Caballero. Tyler Ashbaugh, that's at 2. Rodolfo Aceves. Thank you. Francis Rigby, custody. Victoria Villarreal. Sammy Salazar. Marcelo Flores. Ashley Draper Ward, custody. Is there anyone who came in late or your name was not called? All right, attorney, here are the rules. I don't like repeating the rules, but when I don't, I find attorneys lose their way. So these are the rules for this court. You're not ready to confer with the court if you have not conferred with your client and confer with your state, with the state. If the client is in custody, yes, they need to be brought out. Once you have requested your client to be brought out by the deputy, do not leave the courtroom. The reason why is because for security reasons, there are only so many inmates that are allowed in the box at one time. Do not be selfish to your other colleagues by ordering someone and then leaving. If you have a client who wishes to speak to the court in a language other than English, we're going to need an interpreter. Once the interpreter is requested, do not leave the courtroom because we have a limited number of interpreters and we try to get them in and get them out. When we're on the record, do not approach, do not talk behind the court reporter. Why? Because I want to concentrate 100% on what people are saying to me in case someone has an argument and they're requesting certain things. I do think if you were before me, you would want 100% of my attention and not 98%. So that is why. Why do I explain these things to people when people say you're the judge, you don't have to explain anything? Because I believe that once you know that there is a reason behind things, you will understand and people won't get frustrated by it. This is the criminal trial division. This is family violence. Just pull your file, have a seat. They're going to call you in the order of appearance. State, will you please call them in the order in which they lay their files down? So you don't need to surround them. Just put your file down. They're going to call you and everything is going to run smoothly. Once you're ready to approach the court, just ask the clerk or the coordinator to pull your file, have a seat. There's no reason to stare at me because if I haven't called you, that's because I'm writing something in the system. I'm trying to get Odyssey working. So if we follow those rules, it's going to be a great day. And for defense attorneys, they put notices on every door. Sometimes when you see email and you see things on doors, it becomes spam. So you just ignore it because it's like white noise. But my understanding, that is for you to do e-invoice. And they're having it on the 3rd floor and the 2nd floor. And I think it's until April 4th. So please read that. Proceed accordingly so you can get paid accordingly. So everyone, it's Monday. We're currently alive. Please confer. Deputy Laura?
Yeah, she means it.
We're great downstairs.
She means it. Hi, Siobhan. Good to see you.
I thought I would be down there from 8:30 to 9:30, but we came back earlier. Oh, just ask to approach the clerk so they can pull whatever needs to be pulled for me, okay? Oh, it's John McCarter? Yes, what is happening with this case?
Your Honor, my office set the occupational license hearing for today.
Mhm.
But I spoke to him yesterday and I did not feel he was far enough along.
Okay.
I said, no, he's done everything. And I was really happy until he said that he hadn't gone to an AA meeting. And I said, well, you did the DWS. But we're not going to go before the judge for the AA meetings. So I thought I could reset it. I may have misspoken.
Oh, no problem. Yes, you can reset it. Just speak with the coordinator and she'll put it on whatever date you want it placed upon.
Next week, I told him to get those meetings in.
Okay. All right. Just let the coordinator know so they can put it on the docket.
Okay, thank you.
All right. You're welcome.
One of the most important things as an attorney, talk to your client. If you are a client, one of the most important things, talk to your attorney. Because if you talk and something isn't exactly where you want it to be, tell your attorney will tell the court, and the court, oh, thank you for telling us. Let's fix this. Often it's that easy, but sometimes we see it in these and others, other docket hearings and other courts. People who just don't show up. People who show up intoxicated. But it really is, most of the time, it is this easy. Attorney says, I might have spoken too soon. Can we do a reset? Yes, of course. And yeah. Now you don't overstay that welcome. Because if that happens 3-4 times in a row, oh, she's going to lay you out. Hi. Hello, folks. Good to have you all here. Good to have you all here.
All right, Norma, what date?
31st.
All righty. I can see.
As you can see, I
All
skip
right,
ahead.
State, this is a case, I don't know if it's family violence or criminal trial division. If you all can see if you have any objections.
Yeah, you will see me skip ahead a bit because we are about an hour and a half behind, which means we can catch up. Oh.
Started reading The Fourth Wing.
And it seems like in the background today, we have a black and purple handbag and pink, white, orange, and yellow roses. Hey, always something new.
You did not prepare me appropriately. Not Dylan. You know, in the first chapter. But Sean.
I just restarted that, Judge, this morning.
Yes, not Dylan.
He's the one that was about to get married to his fiance. And oh,
I mean, they didn't prepare you for that. You know, people are talking.
have you read it?
No, here's my thing. I have a lot of books, right? And so whenever I go to the bookstore, they will say, oh, Stephanie, this is something you may like. I read everything. It just depends on the mood I'm in for what genre I read. And so I have Packed in a Box, that entire series, but I have to find it. So instead of finding it, I just downloaded it. And so I started reading it. And let me just tell you, she has not followed any rule that her sister gave her. which may be a good thing, maybe not.
Well, you are in for a, I won't even tell you anything else, but.
No, do not, because, and I'm going to tell Jamisa, but Jamisa always does audio. And when she's driving, she is just like, I have to pull over and stop because this is getting to be too much. But no, I'm liking it. But it reminds me of another series I read, and it's going to come to me the name of that series, but I'm enjoying it. Somebody should make that into a movie, just like they should make Blood Guard into a movie.
I think I don't know if it's Hulu or Amazon, but one of those.
Oh, wow. Don't make me get Hulu just for that series.
I would suggest it. I know you worked on most
State, did you all have a chance to review this request on Christopher Caballero for the return of seized property?
Yes, Judge.
All right, so if you all can approach. And Mr. Caballero, if you'll come forward. Hello. All right, so here's my question. With regards to the seizure of some of these items, has there been a civil suit filed with that?
I don't believe so, Your Honor.
All right, if someone can check on that to see if there has already been forfeiture proceedings that are started?
I know that there hasn't on this one, Your Honor, because the only reason I think that they haven't, because there was a motion that was signed for return of the property, but we did it to Neil Kalfas, and that's why we filed this amended one. So I think that the property's still there. It's not in a pending litigation, but the only thing that we wanted to change, and I let the state know because I know that they don't agree, and they didn't. We wanted to have the items returned to Mr. Caballero rather than Mr. Kalfas.
All right, well, I mean, we can have a hearing on it.
And this, I was gonna let you know, the state agreed to 17 and 18, but that's about it. And that's the currency, and I believe phone.
All right, so again, we're back to the question of whether a pretrial diversion, what does that mean as far as the returning of seized property? If it were an outright dismissal, then.
Right.
So does anybody have any case law on that?
No, Your Honor, and I know that he's not entitled to it. That's what we're requesting it from the court. And that's why I want to confer with the state first, just because I knew that their policy is usually not to agree to stuff like that.
Right, so does anybody have any case law saying that it should or should not? I know what the law says about returning a property that's clearly been dismissed. And if it were just a dismissal and not a pretrial diversion, then there will be no question that it goes back to the defendant. So does anyone have any case law?
No, Judge.
And I don't, Your Honor.
All right, do y'all want to look very quickly, and I'll look very quickly as well?
Yeah, we can do that, Judge.
All right, let's do that. And I'll look as well. So just have a seat. It'll only take a few moments. Research doesn't take that long these days.
Yeah, there's a clear difference between 25 years ago and now. 25 years ago, I hope I have the latest edition of these 7 books. Now, I'll just log in here and search. This new generation of attorneys, you don't know what it was like back in the day. We had to go through snow to get to a statute. We had it was uphill to the law library and back from the law library. Luxury.
I will see you there. Deputy Laura, is Sydney going to try to approach me to be removed from jury duty? That is not going to happen.
Yes, Judge, it is my pet peeve. They say they're curfews and honors and they have to be experienced.
Mhm.
I am. Morning to you too. Yeah, racing through indexes and hoping that law hadn't been superseded. Yeah, I mean, imagine you do all the research and then it's 2 months to trial. You go up there and you make this argument, which is excellent. And opposing party says, well, last week. What? What happened last week? Well,
All right, Rodolfo Aceves. Hi, I'm so sorry. Your attorney told me about your father's passing. I'm sorry to hear that.
Thank you, appreciate it, to be honest.
If you need anything or to talk to anyone about that, just let probation know, okay? And then there was a request for you to travel. So that was approved. So you'll be able to travel. They're going to make you do a UA when you come back.
Mhm.
All right. How's everything else going?
Everything else going pretty good. I still on the same job. Still working on it, and yeah, me and my family are all right and all that.
Mhm. Okay. Well, if you need anything else from the court, just let us know, okay? Ms. Abrams, is there anything else?
No, Judge, his probation officer indicates that he's complying with all the conditions of his probation. He doesn't have any concerns at this point, and they're just wishing to continue to monitor.
All right. So if you keep this up, the court will, of course, consider early termination if you complete everything successfully. You understand?
Yes, Your Honor.
All right. So this is what I am going to do. You know, Fiesta is coming up. Let's not get crazy doing Fiesta, okay?
Okay, yes.
All right. So what we'll do, when do you want to recall this back, Vashon, just to see how everything is going?
Judge, 45 days or 90 days is sufficient. I think 90 days would be sufficient.
All right. Ms. Ferguson, I need a 90-day reset just for an update. All right, so we'll see you back on June 23rd. That is a Monday. Is that good for you?
Yes, Your Honor.
All right.
Just one last thing. I really want to say the thank yous for allowing me to go to Toronto, Mexico.
All right, you.
Visiting my family.
All right, you're welcome. And if you just need something, I always tell people communication is key. Just ask probation. If you feel as though for some reason they're not addressing it, you can always come back to court, okay?
Yes, Your Honor.
All right, thank you. Norma, if you'll give him a reset form.
Yes, ma'am.
All right, thank you. And thank you for dressing appropriately for court.
Oh,
good for this kid. Well, he seems to be in his 20s at least. But if you get caught doing stupid things, you get probation and the ankle monitor and everything. If you do good by that, as you heard, Judge Boyd, we will consider early termination of whatever restrictions he is having on him. Now, for some it's it's hard, but for some it works. So good for this kid. Good for you. Keep going. Skipping to next case.
From Magistrate Wiltshire. With regard to him, I just met with him at the magistrate court, and the court did order an evaluation for him, which is supposed to be conducted soon. They reset the matter till May 1st.
Mhm.
I was going to request a date soon thereafter of that to see about the status of that evaluation and how the MAG court is going to treat the competency issue.
All right, is he on docket today?
Yes, Your Honor. Yeah.
And where is he?
I believe he's still in the back. You want me to?
Yes, Deputy Laura, could you bring out Jose Romero? All right,
Okay.
and when is the
The setting in magistrate court with Judge Lisa Rodriguez is May 1st, Judge. And I did want to let the court know that I have a vacation letter from May 12th through the 16th of that week, but I can do it either before or after.
okay. So they have a competency evaluation scheduled.
Yes, it's already scheduled, Judge. It's my understanding it's going to be conducted with Dr. Lee. And then they're going to send that finding to me and then the prosecutor, and then we're going to evaluate whether I guess it's agreed or contested.
So are they evaluating him on that date, or he's already going to be evaluated on the May 1st date?
It's my understanding he had an appointment on March 21st with the doctor for
Mhm.
that evaluation. But then the court, the magistrate court just, I guess, set it for May 1st because they don't know how long the report is going to, it should take 30 days, which would be, yeah, I guess April 24th.
When is your vacation?
It's May 12th, Judge. So do you guys have availability perhaps between May 1st and maybe like the 10th, somewhere in that week, May?
Well, no, I mean, if you want to, you're saying May 10th, that's the weekend. We won't be here.
Okay, okay.
But do you want it the week of the 5th or something else?
Sure. Yeah, I think actually, Judge, now you mentioned the 5th. I have another setting with y'all on May 5th. So if that day works with you, that would.
Right, we'll put it on May 5th. Norma, Jose Romero, that's going to be coming back on May 5th.
Great. Thank you so much, Your Honor. I'll informally do that as well, Judge.
Okay.
And then I also, on another matter on today's docket, that state just handed me a dismissal. Yeah, can I get a Robert Stevens, please? As I'm up here, I have this motion, sure. Thank you, Your Honor.
Welcome. All right.
Yes.
Okay.
Jose Romero,
Yeah, so
Deputy Laura. Do you see Romero on the docket, the page he's on? It's Jose Romero.
yeah. Yeah, as the word sentence, the seemingly mundane business of court we don't always
Page
hear in
3.
the gallery. Yeah.
All right, thank you.
And I enjoy watching and streaming these because usually we only see the big cases. We don't see the day-to-day business in what goes on before trial, what happens with a plea deal and stuff like that. This is the day-to-day work of judges.
Daniel Montoya.
Better answer. Ah, there he is.
All right, first things first. Defense, do you know when his competency evaluation is scheduled?
No, I do not. I didn't check with Judge Rodriguez's court this morning.
All right, Ms. Ferguson, can you look on Daniel Montoya and see when his competency is scheduled? And then you're asking for his bond to be reinstated?
Yes, Your Honor. And we're not objecting to the same conditions of leg monitor. And for him to, he was actually at the Haven for Hope, and I was able to talk to him. And on the 20th, to let him know about the warrant.
Just 1 second, I'm sorry. Could someone pull the violation report on Daniel Montoya for me, please? Thank you. Let me just have them pull the report.
Okay.
Yeah. When was that? I think it was last year. Dave just put out a stream with him working with the document, and I restreamed it. That was one of the most boring streams ever.
Report, unless you have a copy of it.
Well, mine has writing on it.
Okay.
But may I just add this part, and I'm not going to talk about the violation report. What I'm going to talk about is that once I was able to get a hold of him, he does not have a cell phone. He was at the Haven for Hope, and I told him about the warrant, and he went and turned himself in on the 20th. With his leg monitor on. So just so the court will know that. And that's the relief we're going to be seeking, is that he had another address that Lifetime set up for him, but it was not workable. So he wants to go back to the Haven for Hope with the leg monitor.
All right, thank you. All right, so I am not the one who signed the bond forfeiture. At least I don't think I am, because it doesn't show.
It was an after hours, Your Honor.
All right, so does anyone want to see the violation report?
State does have a copy, Your Honor.
And I have a copy.
So I understand that you're saying he was at the Haven for Hope, but my concern is the charge he has, and it says that he was at Gloria's Hideout, which is a bar, from 7:41 p.m. to 8:14 p.m. And then he was at another bar, the Sunset Bar, from 8:35 p.m. to 9:42 p.m. And then he went back to Gloria's Hideout from 9:44 p.m. to 11:35 p.m. And he never returned.
Yeah, Your Honor, and if I misled you in any way, he
no.
went to the Haven for Hope after, right? On
After the
20th.
bar runs.
Well, he never went in any bars. He doesn't have any money.
No, I
And-
mean, it says here that that's where he was.
No, there's a difference between being in a parking lot and being in a bar.
I'm just saying what this says. So he was there
So
and he wasn't supposed to be there.
he broke curfew. And that his curfew was 10 p.m.
Yeah, that's a bad idea.
So we're just seeking for him to, after he left there, he went to the Haven for Hope. And that's where he, on the 20th, and that's where he remained. They processed him in, even though he had a leg monitor, even with this charge, that he could stay there. And that's where he would like to go back.
All right, so to the clerk, could you pull for me the conditions of his bond?
This is one of these: talk to your attorney, say, I want to go there. They will bring it to court and hope you get approval. Yeah, I understand why he wants to go somewhere where he can get help. But once in the system, you have to check in with the court before you actually go there.
Or put the, just whoever put the conditions in. Oh, no problem. All right, so he was on partial GPS for employment and or school approved upon verification. So it wasn't a curfew. He was only allowed to be out and about if it was for employment. So,
And he was out and about because he did not like where Lifetime arranged for, like, in some, like group home or a place where other people live. He didn't do well there. So, he was just roaming around, and then he decided to go to the Haven for Hope. That was his thing. Judge, he needs, that's one of the beauties of a Haven for Hope, is they'll have access to a telephone for people there to assist him, not only with his medication.
no, but we're still not addressing the issues that one, he's on GPS. It's not a GPS curfew. It's for employment or school only. And that's with approval. So he wasn't working and he was at, whether he went into the bar or not. Did you go into the bar? All right. So he's in a parking lot at two different bars.
And just for the state's record, there's no parking lots. These are on the side of the street. And I have those images pulled up that the court would like to see.
So those are my issues.
Are you saying that this building has no parking, which would, they don't allow people to put businesses up without at least a few parking spaces? So I'm not sure about that. But, Your Honor, I think the issue here for him is where can he continue getting his mental health and be in a more secure place than Haven for Hope, where he can have his mental exam, he can come to court, he can do all of those things. Locking him up doesn't serve a purpose, just he's now going backwards. Because at Lifetime, he was put on medication, he was getting counseling, and
he
now
left Lifetime.
everything is, a Lifetime is great. Now everything is going to be undone. Keeping him in jail doesn't help him, because we know that there's not a psychiatrist that's going to come by today when he gets back and say, hey, how are you doing? You know, how are your medications going? You know, he can't take anything unless somebody, a
Well,
psychiatrist
the
sees
problem
him.
is he's on GPS. I don't take the offense as true or not, but I do have to go by the fact that it's an aggravated assault with a deadly weapon. And
This is his first violation, Your Honor.
he's on curfew. I mean, not on curfew. He's on partial for employment or school only. And we got the tattoo things that are going on here. So, yeah. State, are you in agreement with reinstating?
We are not, Your Honor. The state will remind the court that we were here last time on the 17th, which was the day before this for a sentencing hearing, where the defendant was supposed to be sentenced. There was an issue of competency, so he was released, or not released, I'm sorry, I guess, walked out with the GPS monitor, and the next day he goes to 2 different bars. The state's concerned that he's violating his pretrial conditions. He's not taking the orders of the court seriously. He is going to bars whether he went in or not. I don't have any proof otherwise, but if he's just standing in parking lots of bars, that's also concerning. Additionally, he is a repeat offender and on for a violent offense, which has 2 counts with 2 different victims.
All right.
And so at this time, the state's just.
All right. And also with regards to reinstating the bond, it will be up to the bondsman, number one, whether or not they want the bond reinstated, because I cannot reinstate a bond when there is a commercial bond unless the bondsman has no objection to that. So honestly, I'm not inclined to reinstate his bond either way.
Well, Your Honor, the reason to put him on leg monitor is keeping away from the target, from the individuals that alleged to have been a victim of alleged crime, Your Honor. And that didn't happen. So we're not, the purpose of the leg monitors to keep him away from them. And that he was successful in doing, Your Honor. All throughout when he got out on bond and since he's been on leg monitor.
All right.
Well, yeah, I mean, the first goal is to keep him away from the people he allegedly has done something to. But the restrictions are still there. If he wants to do something else on top of what he is allowed to do, talk to your attorney, attorney talks to court, they talk about it. If you violate it, chances are slim to none that even though whatever cause it was, chances are slim to none the judge will approve it because he chose to violate the restrictions before he asked for permission to go somewhere else.
So we're asking for a second chance, Your Honor, because the purpose of the leg monitor, the spirit of the leg monitor was obeyed.
All right. The motion is denied. I will not reinstate the bond. And we can go on the record. Court is calling 2024 CR 011984 State versus Daniel Montoya. Can I have parties announced for the record for the state? Defense?
Arlene Gay.
And are you Mr. Montoya? I'm sorry, Daniel Montoya. Thank you. All right, Mr. Montoya, your attorney filed this motion to reinstate bond. As I've stated off the record, the court cannot reinstate bonds for a bondsman unless that bondsman informs the court that they want the bond to be reinstated. So the reinstatement of the bond is going to be denied.
If the bonding company comes to you, Your Honor, and they haven't filed an affidavit to surrender surety,
Mhm.
so it was an order from another judge that issued an arrest warrant. So if the bonding company lets the court know, we want to still be on this bond, does that mean the court is saying that you will allow him to continue outside in the free world on bond?
Now, what I'm saying is the first hurdle that the defense has in reinstating the bond is whether or not the bondsman wants the bond reinstated. The court has nothing before it suggesting that the bondsman wants the bond to be restated. So before we even get to the state's argument about why it should not be reinstated, the first hurdle is the bondsman. and the court has no information before it that the bondsman wants to continue to be on your bond. So reinstatement is denied.
Okay, Your Honor.
And if
Can we-
you,
I'm sorry, Your Honor.
no, if you speak to the bondsman and you all want to reapproach after you've spoken to the bondsman, you're an officer of the court. I'll accept whatever you state the bondsman has said. Then we can come back and then we'll go to the next steps.
Okay, great. Thank you, Your Honor.
You're welcome. You're welcome. Brian Pena. Good morning. Any traveling for you?
Thursday.
Where you headed?
Mexico City.
All right. I always love your ties.
Thank you.
All right. On this case, so today is your plea deadline date, is that correct?
That's correct.
So Mr. Pena, are you requesting a jury trial? You need to speak up.
Yes, ma'am.
All right. How long do y'all expect this trial to last?
I was gonna say more four, just because of the amount of witnesses,
All right.
and we would be going to, if anything, jury for punishment.
All right. Ms. Ferguson.
Yes.
I need a jury trial date, 3 days, not including jury selection for this case, please. It's criminal trial division. All right, July 8th. Is everyone agreeable to July 8th?
So just to understand how that works, we pick July 8th?
Yes.
Okay, then yes, that would work.
Okay.
Yes.
All right, what will happen is you'll be brought
Hey,
back
big sis.
July
Good to
8th
have
for
you here.
jury trial. You'll be brought over dressed in whatever attire you have at the jail, whatever civilian clothing you have. If you wish to be attired in something different, you'll have to sign a clothing exchange. And
got it.
counsel, if there's an issue with the clothing exchange, just let the court know and we'll see if we can expedite that.
I got it, Cyrus. I'll take care of it.
All right, thank you. And before you all leave, if the court can get an acknowledgement of discovery.
Yes, Judge.
All right, thank you.
Thank you.
Oh, I'm sorry, sir, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thank you.
Thank you, Judge.
All right, that seems to be headed for court. And plea bargain date expired. Oh, trial, I mean, not court.
Circle go. I'm telling you, I'm watching the circle go round and round on Odyssey. All right, where's Mr. Oscar Jimenez?
He's in custody, Your Honor.
All right, he needs to come down. All right, so counsel, you filed a motion to withdraw,
I did, Your Honor.
and do you wish to proceed on the motion to withdraw?
I do, Your Honor.
Are you retained or appointed?
Appointed, Your Honor.
All right. And Ms. Ferguson, is Mr. Hill on?
Wonder what happened for him to withdraw.
And are you going to have any objections to this attorney withdrawing? Okay. All right, and Norma, if you can see if Scott Hill can appear, please. All right, the court is going to call 2023 CR 2221, State versus Oscar Jimenez. Can I have someone for the state announce? For the defense?
Woodrow Halsted for Mr. Jimenez.
All right, and you are Mr. Jimenez?
Correct.
All right, your attorney has filed a motion to withdraw. Do you have any objections to his motion to withdraw?
No, ma'am.
So what that would mean, if you are still determined to be indigent, which it appears that you would be, then the attorney who would be representing you on this matter would be Griffin Scott Hill. Do you understand?
Yes, ma'am.
All right, and knowing that, do you still have no objections to this attorney withdrawing?
Correct.
All right, state any objections.
Sorry.
All right, the motion to withdraw will be granted. Just have a seat and we'll see if we can get the other attorney to be here. And Ms. Ferguson, if you can appoint Griffin Scott Hill to this case as well. All right, thank you. Yes.
Thank you.
Yep. No objections. Apparently, he wanted out. Client wanted him out. And now we got a new appointed attorney. Again, sometimes it's very, very easy.
My two, I don't say problem children, my two.
Well, here's the thing. This is what I've learned in government life, that you can't say anyone is doing great, because the minute you say they're doing great and they're fabulous, people want to take them.
Yeah,
So they are right.
the troublemakers, right?
They are right.
Uh-huh, no, they really heal real quick.
They're awesome though.
All right, Judge, have a good one.
Don't move them.
No.
Okay.
Broken. Waiting for county, come and fix it. Yeah.
Skipping. I heard a buzz. Hey, Dave.
Hello, hello.
Hey,
Did I
just checking. Yeah, thank you. I'm just checking the docket on an absolutely ordinary court day.
Yeah, no, and I wanted to say, like, nothing should be read into the fact that an attorney's withdrawing. It could be
No.
anything from the attorney's got a conflict on the next hearing date to, he got punched in the jail cell by his client. It could be anything, right? Or
Yeah.
it could be just a simple, communication issue. Who knows? The attorney's leaving the public defender's office. Nothing
Yeah.
stated on the record.
Yeah. He might have a 3-month trial coming up or some. I mean, it could be absolutely anything.
Yeah.
And if everybody agrees, there's no contention. I mean, usually, if there is some contention from the client, he will tell it. He will tell the court.
Yeah, they'll speak up. They'll be like, he doesn't communicate, like Sarah Boone style,
Yeah, and the guy in the McBurney, the Sovsit guy who fired his attorney and then went on a 45-minute, here is why this court and the cops and the judge and the US government owes me over $1 billion.
Yeah. But everyone's on the same page. He's just getting another guy from the public defender's office, and it's not a big deal.
Yeah. Now, I've been checking Judge Burney's docket when that trial actually is going to happen, because that is a murder trial with Sovsit who represents himself.
Nice. Oh, you know what? You and I should talk. At the end of April, there's a Grand Rapids police officer that I featured on my channel a few years ago. His trial's coming up.
Oh.
August 28th. And so I was thinking about covering it, but I don't know if I'm going to be able to cover everything. So maybe you and I can tag team it.
Yeah, sure.
I
love tag teaming cops.
Oh, clipping that.
Yeah. What's the baseline of that case?
So there's a Grand Rapids police officer who pulled over a black gentleman, and the gentleman started fighting with him. The officer, in my opinion, when I was watching it originally, he got too close, he got too confrontational, and then he started to physically fight with a guy who was much bigger than him. Oh. And then at the point that the officer was essentially exhausted, pulled out his gun and shot the guy. Now, his argument is that the guy got a hold of his taser, and it was self-defense. And the guy did get a hold of his taser. So it'll be an interesting trial. But it was in the wake of the George Floyd stuff. It was 2021, I think, it was late 2021, I think, when he was arrested, or when this incident happened. So it was all within that time frame, and it's just now coming to trial.
Okay.
So this should be an interesting case. I'll get you all the details.
Yeah, send it over, and I will make some kind of special of it. And then, because I mean, it's a month from now. Now it might conflict with the YSL trial part 2.
And for a lot of people, it's going to be conflicting with Karen Reed.
Karen Reed, yeah.
So I'm like, well, I'll cover it because it's an interesting case. I started covering it when it first happened.
Yeah.
And so we'll see.
Yeah, we'll see. We'll see. It all depends because No, wait a minute. YSL trial part 2 is scheduled for June. It rescheduled from April to June.
Oh. So you should be good.
Yeah.
But I got to figure out which, who's going to be covering it. If I need to get cameras in the courtroom, if there's someone else going to be covering it. So I'm going to look into all of that and verify the start, verify the start date and everything. And
definitely. Because of our schedules, we can one take mornings, one take afternoons, and stuff like that.
Yeah, I think it'll be good.
Yeah. So yeah.
All right.
And if one can't do yeah, we'll see.
I might disappear for a second. Hang on.
No worries. We are all used to that.
Well, I'm on my iPad, but I want to do it a different way.
Sideways?
No. Hang on. I'm sending you a link so that I can get at it myself. And open. I'll be right back. Hang on. Let me figure this out.
Yeah. Well done, Dave. Yeah, bring flowers. Here he is again.
See, this is better. This is the actual StreamYard application on my iPad. I like this a lot better.
Yeah. But you still have it on the horizontal, maybe if you...
Well, because if I do it this way, then I feel like I'm like always looking down and off to the side.
Oh, okay.
But maybe I'm going to spin you guys around a bit.
You spin me right round, baby.
Baby, round like a record, baby.
Round.
Good song.
And everybody who was alive at 80s, you're welcome. Now that's in your head again.
There we go. All right, how's that? Is that a little better?
Yeah. When I had an iPad, I had the same issue. So I took one of these yellow round thingies and put it on the middle of the side. That way I looked at that.
Oh, yeah. So you can see where it is. Yeah, because I need to be looking right there if I want to look at the camera. Otherwise, it's just like I'm
not
off.
Interested.
Yeah. Yeah, and it should also sound better too.
I want your love. Da, 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 da.
I'm just sending out a stack of subpoenas, so I figured I'd join you for a minute.
Yeah, we will not quit our day jobs for a new career in singing.
I thought we were pretty good. I love the karaoke.
I need a lot of beer before I think I can sing.
Okay. When you send out a bunch of subpoenas, it's like an assembly line. You just sort of get everything together and.
Yeah. I rarely do subpoenas, but I do call for negotiations. And since I am do it through the union, they have to show up.
Yeah.
And if they don't, next meeting, since you missed the last one, the fine for that is this amount of money. Do you want to come this time, or do you want to skip another time and owe us even more money? And no, we don't even need to go through court.
Speaking of, I need to, when we're not on stream, I'm gonna give you an update on my union case.
Oh yeah, please. Yeah, definitely. That's been going on for a year and a half now.
Yeah, this is actually, the subpoenas are for that case.
Oh, a year and a half later, hey, subpoenas. But that means you are preparing for. Is it subpoena for trial or subpoena for depositions?
It's actually subpoena for documents, but I will say this, that the original plaintiff's counsel is no longer on the case. I guess he was kind of sick, and everything really wasn't happening. And so we're just kind of starting the case now, a year and a half later, because we have new plaintiff's counsel.
Okay.
So now we're actually getting somewhere.
Yeah. Good for you.
Another reason why somebody might withdraw, right?
Yeah, definitely. They fall ill, or their bar card is withdrawn. I mean, there's a lot of reasons. Or they might, as in a case you talked about a few days ago, they might forget to actually ask for permission to practice in that state.
Yeah, that could be too. Yeah,
that sometimes that kind of puts a damper on the case when you forget that you don't have permission to practice.
Yes, it does. Definitely hamper the matter.
Yeah, Mr. Busby, it's kind of a big deal. Oh. Hey, look, Leftist Gaming Lulz. I haven't seen you in a bit.
I am working, sir. I'm working right now. I'm sending out a stack of subpoenas. You're getting one.
What's going on? Why is sound not on this? Did you do anything to the sound on?
No, I can't when I'm on the app. Did I do something when I
have given this?
Oh yeah, no sound. It just wasn't sound at that point.
No, when I'm on it through the web browser, I can, but not through the app.
So this entire thing, she should. But here's the thing with Judge Boyd is, if it's somewhat sensitive, she just mutes. For some, and it can be because of reasons, but sometimes it's because, hey, this guy did something to. Yeah,
I've noticed that.
Yeah, so because she really has full control on her courtroom and the recording and the audio and everything. And
there's another Michigan judge that I'll send you a link to. She streams everything, and it might be interesting. You can watch it a little bit and see if you want to stream her.
Yeah, I mean, I'm interested because I have Judge Boyd, Judge McBurney, sometimes Judge Fletcher, and stuff like that. Because just to have a mix, because this is in Texas, 187th district, which I believe is somewhere north of Houston. But everything in Texas is north of Houston, so
right. Let me find her. The reason I found her and started following this judge's channel is because she's been doing the preliminary examinations of the electors from Michigan that are being charged criminally with falsifying electors for the 2020 election. That's still going on. And the preliminary examination is still going on. And it's like once a week, 1 day a week, they do that preliminary examination and continue it on those 5 electors or whatever. But she's doing her other stuff in between. So I'll send it to you.
Yeah, please do. Let's see here. 187th Criminal District Court is in San Antonio, Texas. I have no idea where that is.
What do I want to know about Texas?
Bexar
I've been to Texas
County.
3 times. I'm good. I'm satisfied. I've been there.
Let's see here. Where is San Antonio? Is it's due west of Houston. It's about 3 hours from Houston. Due west, just south of Austin. Okay, I didn't know that.
20. Hello, good morning. Thank you for dressing appropriately for court. All right, where are we on CPS records?
Judge, I need to file a motion to have those CPS records released, which I can do this afternoon when I get back to my office. I have given the state a thumb drive for discovery. I believe I received that thumb drive back, but I have not filed a motion for CPS records.
All right.
Protective order will need to be signed as well.
Okay. And let me see, just a moment. All right, and state, were you able to tender an offer?
I gave an offer. I know if defense looked at it in the file. I can show them right now.
Okay. And sir, how old are you?
I am 26 years old now.
All right. Ms. Ferguson, I need a 30-day reset for plea deadline, please.
It's bad when they need CPS records to continue your criminal case.
Yeah, May 1st.
All right. Your plea deadline date is May 1st. On that date, you need to let the court know whether or not you've accepted the state's offer. Do you understand?
Yes, ma'am.
All right. Once you sign the reset form, you're excused. And state, if you'll submit the protective order, I'll sign it.
Yes, sir.
Yes. Well, that's Norma giving that date. Norma gave that date. Let the record reflect. All right, May 5th. Vashon? All right, thank you.
May I approach, Your Honor?
Just one moment. State, Norma was giving out a May 1st date, and Rick just stood there and accepted it. So that's fiesta time. Counsel, who are you here for?
Judge, we filed a light of day red last night. I think if you have a copy in front of you. I filed to the state. They don't seem to have any disagreement. He was indicted on a Sunday, should have been, should have been indicted on a Sunday. That was the 90th day. He was indicted on a Monday.
Well, Your Honor, the state's objection is, well, I'm in agreement that we unfortunately did not get this case indicted by the 90th day. So no objection to that part. What I'm objecting to is him being released on a PR bond. We would ask that a bond be set in this case with conditions of release.
Well, here's the thing. He needs to be present because number one, I don't know if he can afford a bond or not. I don't know how much the bond should be set at. So
we'd ask for a PR bond, Judge. And
I need him here because according to the delay rules, he needs to be given a bond that he can make. I don't know if he can make a bond. Maybe he can make a bond.
He's been in jail for over 90 days, Judge.
All right. Yeah. So, Ms. Ferguson, set Mr. Terrell Joseph Kirk Jackson, please, as soon as possible. Okay. I can't hear it today. Your client is not present. If you want to talk to them,
I think it's just a matter of numbers, Judge. If you agree, then he would be in jail. He'd be out of jail. If you disagree.
Well, I can't set a PR bond for him because one.
Why is he not there?
I don't know. He was taken into custody. He's been in custody, right? And they're talking about the indictment being late, and so they want to set a PR bond, but he's apparently, they didn't walk him down from jail, it sounds like.
Yeah, and that sounds intentional. Because this is, well, it depends. If this attorney is the person who called this after the 90-day, I don't know how it works in Texas. How would it work in Michigan?
So depending on where they're at, but generally because they're in the county jail, which is where the court would be, the court would issue an automatic writ if you set a hearing for a particular defendant's case. If for some reason the court didn't, you would have to file a motion for a writ to have him transported. But normally it's just automatic. It's like, all right, we have a hearing up on this guy's case. We need him here. So the court would just writ him out.
Yeah, it should.
Yeah. And a writ is just an order telling the sheriff or whoever's in custody of the guy to bring him to the court at this time and date.
Mm. Yeah. As Dark Lotus said, this attorney is trying to help his client and the jail is effing around.
Yeah.
And this is one of the things that sometimes pisses Judge Boyd off.
Yeah, she's probably not going to be happy about this, but we'll see how she handles it.
Mm.
I don't know if he can afford a monetary bond. I don't know what conditions should be set because he's not before me. Ms. Ferguson, if you would put this on the docket ASAP, please. Thank you.
Thank you, Judge.
You're welcome.
Excuse?
Yes.
Yeah. So Judge says, put it on the docket as soon as possible. And then she will order the jail. Yeah, this guy up here now, more or less.
Is this also the judge that years ago went off on the jail for not providing female
And
products?
counsel, if you want to see if you
Yep.
can see if Judge Nahara can give you an earlier date.
I'm sorry, Judge.
I said, if you want to see if Judge Nahara can give you an earlier date, you can, because that is what that court is for.
Oh, okay. If you don't mind that.
No,
Great. Thank you, Judge.
you're welcome.
No, I haven't said it. If you want to go talk to him, I'm calling him.
Yeah. But she can't do anything until that guy is actually there. But I would assume she will not be happy with the prosecution, who after the 90 days says, hey, we oppose this, let's have a bond, and and she, well, can't do it. He's not here.
Yeah, I mean, it's not really on the prosecution to writ him out. It's really on the sheriff's department or the police, whoever has him in custody.
Mm. Yeah, but they missed the 90 days. And I mean,
yeah, that's
yeah. Let's see here. 187th district prosecutors. Let's see how many they are. Bexar County District Attorney's Office. Let's see. Let's just check division chiefs. They have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 chiefs within the district attorney's office. But how many? How many are there? Let's see, misdemeanor trial division. Let's see here. They really don't like putting the people on their page. Dun, dun, dun.
What's today's date? 24th.
County departments and no, not that. District Attorney's Office. District Attorney Jody Gonzalez. But yeah, I don't find an actual number. XR County, how many prosecutors? Hey, Dolly just showed up. Hey, Dolly, thank you for the raid.
Oh yeah, he's covering that Pee Wee Herman judge.
Yeah, I know. He's getting decent numbers once in a while on that one. So good on you. Good on you, Dolly. Good on you, Dolly. Well, I can't actually find the number of district attorneys or ADAs in Bexar County, Texas. If anybody finds it, let me know, but I can't find an actual number. That's not good. Who is this MLS person? Yeah, he just shows up once in a while. Hi, Dolly. Yeah, I'm muting Dave because I can hear him type. Yeah, which is kind of ironic coming from me.
I know, right? Yeah.
But
Don't
it's
have my
different
normal
when
quiet keyboard here.
It's different when I do it.
Yeah, sure.
Okay, Bexar County is pronounced Bear County. Of course it does, because apparently you have French pronunciation. I don't know.
Bear County?
Yeah.
Bear County? Okay.
Skipping ahead to the next case. Let's see.
It's 187th district
Today.
or court.
Excuse me.
Oh, she's getting feisty.
Is school in session today? Yes, what? All right, so shouldn't he be at homeschool, being schooled? All right, so why are you all bringing him down here when he should be being homeschooled?
Because he's being educated.
No, that's what visitation is for on the weekends. Do you understand?
Oh.
All right, state, if y'all have any objections.
Is the kid a part of the case?
I have no idea. Hey, MG Law is here.
Bear County.
I'll send MG a link. If you have time,
right,
MG,
I don't even
send
recognize
you a
that
link
signature.
on
I'm sorry.
XDM.
Oh, is that you?
Yeah.
Oh, okay.
Blue.
Okay.
Yeah. Usually it's on a computer. That's
Yes.
why. Yeah.
Don't oppose that either.
All right, thank you. Two.
Skipping ahead again. There's a huge German influence on text and history. Okay, I doesn't mean Bexar is pronounced there. Oh, MD Law brings his daughter to court, homeschooled, make it part of her school that day.
Yeah, that's what I was saying. Like, there's nothing wrong with the kid being there. I've taken my kids to court to let them watch in.
So they really learned that not all criminals are bad people, which will in no shape or form influence their choice of partners later in life.
Now I'm going to mute myself because I'm printing.
Okay, thank you. Skipping. Yeah. Also, ordinary court day, judge does work in between. Oh, and she's gone.
The other, or do you need both?
Let's see here.
All right, the parties on Draper Ward. Good morning. How's it going?
It's going.
Where is the pen?
Judge, I don't know yet. I think I was coming to see you today. I usually try to pin one on if I know.
All right, so we are here on a motion to revoke. Are both parties prepared to proceed?
Oh, revoke.
Oh, I'm sorry. It's right here. It's under my
Sure. All right, the court is going to call 2024 CR 1983, State versus Ashley Yvonne Draper Ward. Could I have parties announce?
Andrew Harris, for the state.
Melissa Christian for the defendant.
All right, and Norma, could you hand me a file stamp for a motion to revoke? And are you Ashley Yvonne Draper Ward? You're gonna need to speak up.
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Ashley Yvonne Draper Ward who was placed on deferred adjudication in 2024 CR 1983 for the offense of attempting to take a weapon from an officer on June 27, 2024 for a term of 4 years? Is that you?
That's
Yes,
generally a really
right,
bad
state.
idea.
On or about the 23rd day of December 2024 in Bear County, Texas, the defendant Ashley Yvonne Draper Ward committed the offense of tampering with electronic monitor violation.
How do you plead to that? True or not true?
True.
State waives the remaining violation allegations.
Any objection?
No, Judge.
All right, did you understand by pleading true to violation condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is not, Judge.
State, what are you requesting?
Adjudicate guilt, assess punishment at 2 years of confinement in the state jail facility.
All right, in defense, what are you requesting?
Judge, she has 415 days credit. So we are asking the court to give her credit for time served.
All right. So you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Ashley Yvonne Draper Ward.
All right, what have you done while you've been on probation? Well, let me do this. Did you complete parenting classes?
I did several of them.
But did you complete it?
No.
Why not?
Yeah, that was gonna be the answer.
Deputy Laura?
The program.
Excuse me. You're not dressed appropriately for court.
Oh.
Yes.
Because I left the program.
All right. Why did you leave the program?
I acted on impulse.
All right. That doesn't explain why you left the program. What was the impulse you were acting on?
Just overwhelmed. There was a lot going on up there, and I just got fearful when I left.
All right. Did you complete anger management?
Yes, Your Honor.
All right. And with regards to the referral for Center for Health Care Services, had you been in contact with them?
Yes, Your Honor.
And were you employed?
Yes, Your Honor.
Doing what?
Worked at Little Caesars, and then I was a home health care provider.
Oh, see, I don't even know why that's being allowed, because I don't allow people to be home health care providers. And I specifically said no employment as a home health care provider. You're overwhelmed by life, and yet you're somebody's home health care provider. But I don't allow people who have felony cases to be home health care providers.
Yes,
So that's number one. Probation, what are you recommending?
Judge, probation's recommendation is to amend for safety followed by aftercare.
All right. You have a choice. You can go to safety, or I can revoke you. And if I revoke you, I'm sentencing you to the 2 years. Either way, time is going to pass in your life. It can either pass with you in safety, and you're going to get extended on this probation, by the way. If you go to safety, I'm going to extend you for
What is
a year.
safety? Do we know?
So if you want to just do your time, you can do your time. You can go to the state jail facility. I'm going to sentence you to 2 years, or I will send you to safety.
What county is this?
Bear County, Bexar.
You'll get credit. The judge will give you credit for time served. State jail does their own calculation.
All right. This is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 2 years in the state jail facility, give you credit for any time served. There's a $500 fine, time and money for run concurrent. And I'll recommend the therapeutic community. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
You have a limited right to appeal, and that right to appeal is that it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. So you're going to be sentenced to the 2 years in the state jail facility. You are entitled to whatever time that you've previously served. And I'm going to recommend the therapeutic community. The therapeutic community is to help you hopefully get your life in order so the criminal system will not see you again. Do you understand?
Yes, Your Honor.
All right. Good luck to you.
Yeah, it's an inpatient
Thank you.
rehab
Thank you.
service.
Yes, thank you.
She chose prison over rehab, inpatient rehab.
Yeah, some people just don't want to quit. They would rather spend, well, she's been in jail for a year and a half, and she would rather have those months in prison or jail and go out.
But there's also an aftercare program that runs for like an additional year. So maybe she's looking at like, well, if I just do my 6 months in jail,
yeah,
then I don't have to worry about 2.5 years or 3 years of this thing.
Okay.
but still.
Yeah.
It says it says it's for high risk substance abuse offenders. I don't know what means by high risk, but apparently she was also sentenced to anger management, so maybe there's behavioral component to it.
Yeah.
She's got a girlfriend in jail. Yeah, she might. Don't know.
Yeah.
Can't communicate with
Lucia
your
Maria
prison wife if you're
Villarreal.
in rehab.
Thank you. How's it going?
Good, Judge. How are you?
All right, Fiesta is almost upon us, right?
No, fortunately.
They shouldn't have Fiesta during tax season or tax season during Fiesta time.
Well, I have a daughter that's April 13th.
Oh, wow.
And my sister's the 15th too. She's a
Yeah,
tax.
my mom is in April too. The Tauruses rule. All right, so where are we on this case?
Judge, I believe that this is her first setting. I know it's an older case, but it was an at-large. She was just arrested in February. This is our first setting. We've reviewed the case, but there is some documentation that I need to get from my client.
Okay.
I can provide to this.
All right, do you have all of the discovery?
I believe I do, Judge.
State on Maria Villarreal, were you able to tender an offer? On Maria Villarreal, it's a drug case. Were you able to tender an offer? All right, so if you can tender an offer, and Ms. Ferguson, set this for a plea deadline date in 30 days. All right, so April 24th will be your plea deadline date. Thank you for dressing appropriately for court. Do you have any questions about anything? No. All right, once you sign the reset form, you'll be excused. Just have a seat and your attorney will bring the reset form.
Wait a minute, it's her first. She's not a spring chicken.
Wait, so I looked up what the at-large thing was because they said it was an at-large. Is it animal at-large? So she let a dog off the leash or something?
I have no idea.
Well, because the only thing that I find in Texas as at-large is an animal charge. Typically refers to a violation of the local or state ordinance regarding roaming animals.
Oh, so she walked her dog without a leash, and now she's in court.
Yeah, apparently.
Yeah, I mean, you go from one case to another. Previous case, a bit more serious than this one.
Well, at first I was thinking, is it like an at-large murder case? You know, like a murder at large or something. Maybe it was like a term of art that Texas used, but no, it appears in Texas it's animals, allowing the animals to run at large.
Yeah, okay. You never know. You never know.
To you. Okay. All right. Thank you. Thank you. Thank you.
Thank you, Judge.
She dressed appropriately to court. Yeah, one of the things you really want to do, you don't show
All right, who's
up
here on
in
Daniel Chapa?
Don't show up in F the police to court. That's
There's
generally a bad idea.
There's a district court here in Michigan that if you are wearing jeans or shorts or anything that the court deems inappropriate, they will send you home to go change. And if you miss your court date, when they call your case, then they're going to issue a bench warrant. But all the notices have the dress code in like bold highlighted text. There's all over the building on the outside and in the courtrooms. Like, don't walk in here in jeans and shorts. But if you do, you're sent home to change and don't miss your date.
Yeah, some take that very, very seriously.
I do too. I always tell my clients, dress like you're going to church.
Yeah. I never go to church. Should I go nude?
Yes, definitely.
All right, who's here on Daniel Chapa the fourth?
Daniel Chapa.
Who's the attorney for Daniel Chapa? Court is calling 2024 CR 011378 State versus Daniel Chapa the fourth. Could I have parties announced?
So Daniel Chapa, and his fourth generation, Daniel Chapa. Okay, that's a choice.
Megan Galloway from Steve.
Ryan Kimbrough from Mr. Chapa.
And are you Mr. Chapa?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there are no applications. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
We're waiting for visual justice.
Any objection?
Objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance penalty group 1, less than 1 gram. That is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Oh,
If you have a
Texas has more or less similar drug laws as Sweden has. Less than 1 gram. Okay, that's
plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you understand?
No.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Chapa, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Oh, ma'am.
Anyone promised you anything other than the plea?
Oh, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 9 months in the Bexar County Jail
wow.
under 1244.
For less than
There's
a gram.
an $800 fine. And the state is taking in consideration 2024 CR 011211. Did you understand that to be the plea?
Yes. Am I getting back time? Yes, ma'am. I understand.
Defense, is that the plea?
That is the plea.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
No objection.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? And state, you may be excused. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront
Yes, ma'am.
any witnesses the state would call in the right to remain silent?
Ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he's been in jail for, I believe, 129 days on this case.
Less than a gram and has been in jail for 129 days. Yeah, that will get you a plea deal. I'm not overly fond of these long incarcerations.
He's going to get out with time served. Sounds
Yeah.
like.
It's more to do his family. He does have a lot of family support. I'm asking the court to file a complete bargain.
All right, so you have a lot of family support?
Mhm.
Then why won't you do right?
That's what they get mad at me all the time.
No, I mean, I'm not mad at you. I'm just wondering why won't you do right? Here you are.
Fall short.
Here's the thing. You're falling short a lot. And let me just tell you something. You're worried about whether you're going to get credit for any time served. Legally, I have to give it to you. If I didn't have to give it to you legally, I probably wouldn't give it to you.
Oh.
And the fact that you are sitting out here tattooing weapons on your face and doing all this extra nonsense, which is nonsense. I don't know what your plans are. Who do you think wants to hire you or would hire you with a weapon tattooed on your face?
It's hard for me to get a job. I regret it.
Yeah, it's hard for you to get a job. And yet you continue doing foolishness. You started with the neck tattoo. And I always tell people, here's the thing. I don't have any problem with anybody having a tattoo. Go forth, be you. But if you're trying to get employment, maybe you should consider not having tattoos that come above the clavicle. You understand?
You're honestly right.
All right. The court is finding you guilty. The court will sentence you to 9 months in the Bexar County Jail under 1244. There's an $800 fine. I'm not running time and money concurrently. Taking consideration 2024 CR 011211. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Do you love anybody more than you love yourself?
I do.
And who is that?
Family.
Great question.
All right, so here's the thing. You're using drugs. There are plenty of places in Bexar County that will give you help with your drug addictions. Don't make it hard on your family by either spending the rest of your life in somebody's prison or somebody's jail, or because you've overdosed, if you've gotten a bad batch of drugs and there's somebody that needs to be identified. You know who they call in to identify the body? Family members. Don't put that on your family. You understand? All right. Good luck to you.
Thank you.
You're welcome.
Yeah. So,
sure.
Face tattoos with weapons and a teardrop. So either he is a really tough gangbanger or he is a poser. I would say he's a poser.
I like how the judge speaks to some of these people, though. And she's just a no nonsense. She's like, "This is the reality of the situation. Maybe don't get a neck or a face tattoo. Probably not going to get a job."
Yeah.
Go ahead.
I have a bunch of tattoos, but all I have to do is roll my sleeve down.
Exactly.
Yeah.
I need to jump off and work on a couple of things that I can't do on stream. But I did send you a message on Discord with the Court of Appeals decision on that Grand Rapids cop. So if you wanted to sort of get up to speed on where we are going into the trial.
Oh, so it was remanded down to the trial courts again.
Yeah.
Okay. Yeah, then I have, and it's April 28th scheduled. Yeah, I will check it. Because, folks, times are different now than 4 years ago.
They are. It'll be interesting. He's claiming self-defense. And the Court of Appeals decision kind of goes over a lot of that. And that's, so he hasn't had a trial yet. It was interlocutory appeal, like before the trial. And so this will be his first trial, but you can kind of get an idea of where the court's going with this. So that might give you some good insight. Wait, what's with? Oh, Lolita Smiles. By the way, Lolita Smiles gave me a great lead for yesterday's stream. So thank you again for that on the Diddy case.
Yeah. Yeah.
All right. I'm gonna
Yep.
get to work. I guess pay the bills a little bit.
All right. Thanks for joining and thanks for your input. Yeah.
All right. Take care.
See ya. And we will continue. And skipping ahead.
Trevino. All right, who's here on Aaron Joseph Mendez Trevino? All right, so on this case, where are we on discovery?
Judge, I think there is some discovery I need. There's also a case in intake that's similar. I'm trying to get the details on that's not indicted. I did get a preliminary offer on this case that we're approaching the court on. But I do think I am missing some discovery from the case that's not indicted yet. And I'm gonna see if we can exchange that over the next week.
All right, and how old are you?
18 years old.
18. Miss Ferguson, give me a 60-day reset date. That's going to be your plea deadline date.
Good.
I can do May 20.
All right, your plea deadline date is going to be May 22nd. On that date, you need to let the court know whether or not you've reached an agreement with the state. If you've reached an agreement with the state, then your case will be disposed of that day. If you haven't reached an agreement, you will be set for jury trial. Do you understand? All right, thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused. You're welcome. You're welcome.
Yeah. Ordinary docket day. Skipping ahead to the next one.
Good, okay.
Oh, there we have one.
All right, so on.
Let's see, skipping back again.
Jeffrey Guerrero.
Scott Sullivan for Mr. Guerrero, Your Honor.
All right, hello. Good afternoon. Let me see. All right, so on this case, where are we on discovery matters?
If I could briefly,
yes,
quickly, and I spent a lot of time with him last week and this weekend. Do you still want me to be your lawyer, sir?
Yes, sir.
You're comfortable with that?
Yes, sir.
And Judge, I thought that was one of the base reasons. And we've got most of the discovery, I think. And I think I need to check with them on a few other matters.
Okay.
Likewise, I need to talk with somebody, with an attorney who's on the panel, but also was up in Denver, Colorado as a previous, he used to work arsonist. And he might be my expert. I'll talk to him about that and approach the court in the days to come about that. Whenever the court wants us, set us for trial, we can go. But like maybe a month or so for me to get it. I don't know. I don't want to tell the court how to run its talking, but it would be helpful if we could get that. Oh, and last thing, we do have a motion for PR bond for him. If the court can set that maybe later this week, I'll have some witnesses here.
All right.
Just so you know, some lawyers will work until they literally can't work anymore. This guy is past retirement date in years, but he might be an excellent attorney and he loves his work and he just keeps going.
All right, Miss Ferguson. Are we able to call back this week or next week for a hearing on a request for PR bond?
Yeah.
All right. So that's the earliest we can do it, okay?
31st is fine. I'll be here.
I'll set, so March 31st will be for your motion for a PR bond. And then the next thing is I need a plea deadline date of 30 days, please. All right, so April 24th will be your plea deadline date. On that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not, your next court date will be your jury trial date. Do you understand?
And I wanted to make sure I had the dates right, the 31st for the motion.
Yes.
And then what was the other one, Your Honor? I apologize.
Plea deadline.
Plea deadline.
Yes.
And thank you, Your Honor.
All right, thank you.
Now be excused.
Yes.
All right. Good news for that guy, I assume.
All right, who is here on Cavanta Thomas? Who's the attorney for Cavanta Tyrone Thomas? All right. All right, is this a plea?
Yes, it is, Your Honor.
Court is calling 2024 CR 008-305 State versus Cavanta Tyrone Thomas.
Good to see you.
Could I have parties announced?
Megan Galloway.
Anthony Miller for Mr. Thomas.
And are you Mr. Thomas?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Thomas, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into this plea?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
So, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Off the record for a moment. Cindy, you need a cough drop?
Yeah. Yes.
Okay. Do you need any water?
Yeah, I've got a drink.
Okay. Just let me know when you're ready.
Okay.
All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at a cap of 4 years in the prison. There's a $2,000 fine. The state is silent on your application. This will run concurrent with 2024 CC 740267. The state is taking in consideration 2025 CC 002368. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That is correct, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, my dear.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We've had an opportunity to review, Your Honor. We have no objection.
All right, and state, have you spoken with the complainant?
Yes, Judge.
All right, thank you. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits, one in attachments, and review the same.
Yes, ma'am.
All right, after reviewing state's exhibits, one and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We're willing to do that, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. At this particular time, Mr. Thomas has fully acknowledged that he handled the situation improperly. He did not intend to harm anyone or cause any type of conflict, Judge. He was under the impression that this individual had taken items from him and were tracking him on his
Well,
phone.
according to the stipulated evidence, he was correct in his assumption. So here's the thing. At the end of the day, I understand that people get frustrated when people steal things from them because people have worked hard for what they have. Why somebody needs some Louis Vuitton earbuds, you know, that's what people can spend their money on, whatever they want to spend their money on. But this is definitely not the right way to handle things, because when you do that, so many things could have gone wrong. Do you understand?
Yes, ma'am.
All you had to do was call the police and said, these are where the earbuds are. I'm tracking them. That's it.
Yes, ma'am.
Now, guess what's going to end up happening? Now you're going to be on deferred adjudication for a felony when all you had to do was pick up the phone. And then I will tell you this, if things would have went truly sideways and you would have ended up perhaps killing somebody or you perhaps being killed, then we'd be in a whole different situation because you'd be charged with murder. You understand?
Yes, ma'am.
So the fact that, you know, there's a theft, that is no excuse. Okay?
Yes, ma'am.
All right. Are you employed?
Yes, ma'am, I am.
What do you do?
I drive 18-1,
Okay.
a third-party contract for the military.
All right. And do you go out of state?
No, ma'am.
Okay. So do you just drive throughout Texas?
Yes, ma'am, correct.
Do you have any children?
I have one.
Age?
3.
All right. And see, they were asking for forced silent. You could have been away from your child for 4 years if I would not have granted your application. You understand?
Yes, ma'am.
So you got to start making better decisions. All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs, or there can be the patch. The patch costs more, but since you're a truck driver, that may help you as far as taking UAs.
Yes,
The patch is a device that they put on you. You're not allowed to remove it. They put it on and then you come back when it's time for it to be removed, and then they'll see if there are any positives. You understand?
Yes, ma'am.
There is to be proof of employment within 30 days, no employment as a home health care provider or with minors. He's allowed to travel. State, any objections to allow him to travel throughout the state of Texas for his employment? He's a truck driver. All right, he's allowed to travel throughout Texas for employment. Just make sure you let probation know. You understand?
Yes, ma'am.
There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the court will deem 50 hours satisfied. I'm going to order anger management. And once that's completed, the remaining 50 hours will be deemed satisfied. There's to be field visits 1 time per month for 3 months. Probation. Is there anything else? Is there anything else you need from the court in order to be successful?
Judge, the only thing we bring to the court's attention is Mr. Thomas is currently on GPS full house arrest. So we would like, of course, to have that removed.
All right, and I'm sorry, just 1 second. Take in consideration 2025 CC 002368, and this is the run concurrent with 2024 CC 740267. State, with regards to the GPS, any objection to the removal? All right, and the court will order GPS removal. And there is an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Is there anything else that you need to be successful on this probation?
Just you give me another opportunity to get my life back straight.
She has.
And
All right. So here's the thing. When you're on probation out of this court, on probation anywhere, you know you're not allowed to drink alcohol. You understand?
Yes, ma'am.
In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not following the court's instruction that allows you to travel throughout Texas for employment, tell probation. That's what the judge ordered. If there's still an issue, you can always come back to the court and address it. Do you understand?
Yes.
All right. Thank you for dressing appropriately for court, and just remain in the courtroom, and probation will go over conditions.
Yes, ma'am.
All right. Good luck.
Thank you very much, Your Honor. May I be excused?
Yes.
Yep.
First bench, sir.
If you get something stolen from you, is it really worth chasing after and do an assault? Especially if you have kids. You don't really know if that person might be armed, and all of a sudden your child is fatherless. So might not be worth it. And in this case, all of a sudden this guy has a criminal record for a pair of earbuds.
And it's
Okay. Let's see the next one.
Flowers. All right, Marcelo Flowers. I'm sorry, Flores. Marcelo Flores. Thank you. Hello, Nipa. How's it going?
I'm good, Your Honor. How are you?
I cannot complain. It's a beautiful day. We're all currently alive. We can't beat that.
That's right. No use complaining anyway, Your Honor.
No.
Somebody always has a bigger problem than you.
You know what? Like the song says, you got to have high hopes.
That's right.
All right. Yes. Oh, don't make me, because I will. I remember it from,
Laverne and Shirley.
well, I remember it from Laverne and Shirley, but also you remember they did a movie of it, but they also did a, play, Damn Yankees.
Oh, I never saw that one.
Oh, you should watch Damn Yankees. It's about this guy who, makes a deal with the devil, right? So he always wanted to be a baseball player. So he is turned back to young and he becomes this famous baseball player. But then, of course, he misses his wife and everybody. So you got to have high hopes. Oh, but Sean, I'll talk it.
You never,
All right, court is calling 2024 CR
never know what they will talk about in the intermissions.
0443 State versus Marcelo Flores Jr. Can I have parties announced?
Jason Pierre, here for the city. Nipa Carrillo for Mr. Flores.
And are you Mr. Flores? All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Marcelo Flores Jr. who's placed on community supervision in 2024 CR 0443 for the offense of possession of a controlled substance, penalty group 1 gram to 200 grams on May 21st, 2024 for a term of 6 years? Is that you? All right, state.
Yes, Your Honor, violated condition number 41 on or about the 18th day of February 2025 in Bear County, Texas. The defendant, Marcelo Flores Jr., the then and there, failed to comply with the rules and regulations of the felony drug court by failing to attend treatment as scheduled in violation condition number 41.
How do you plead to that?
This is chief.
All right.
I will waive the remaining violated conditions.
Any objection to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, and sentence you up to 6 years in prison and up to there is no fine, but sentence you up to 6 years in the prison.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, ma'am.
Court is going to find violation of condition number 41 true. Is there a proposed agreement?
No, there's not, Your Honor.
State, what are you requesting?
Notification, Your Honor.
All right, defense, what are you requesting?
Your Honor, we request to continue Mr. Flores on probation. If you looked at his the recommendation by he's going to judge.
All right, any objection?
No.
Yeah, and he was doing very well, Your Honor, very well. He had two in February. He had two, one by admission, and the other, I think, by urine for drug test, a dirty UA. The reason we're here is because he didn't finish his drug court.
All right.
All right, and so he was told that he's just going to get a 30-day sanction for it, and 30 days are up, and that's why he thinks he's here. But okay, so we know that. So we're going to leave it up to you, Your Honor. He wants to be continued on probation. He wants to have another chance at drug court. And like I say, he was doing so well, and I don't know, something must have happened. And so he given another opportunity to do drug court and proceed with his probation.
All right. You okay, Cindy? Do you need a break? I have my medicine there that's for the coughing. Let me just grab it. Yeah, no.
Yeah, staying sober is sometimes really, really hard. I mean, he was put on probation 2021 for 6 years. This is 2025.
Oh,
Get that tickle in your throat.
Oh, and it doesn't go away, right?
Does not go away.
So let's see what Judge Boyd eventually decides.
and Yaya. All right, so I'm going to take up Portales and Courtney Sloan. Then after that, we're going on recess.
Okay.
Unless you have anything else that's ready. All right, we're back on the record.
Oh, and the alternative, Your Honor. The probation did recommend, lifetime recovery followed by ISF. And so, but also all he wants, Your Honor, to consider, give him another opportunity for, drug court and continue him on that probation.
All right, do you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. Marcelo Flores Jr. All right, so you were sent to felony drug court. Why didn't you successfully complete it? Can you repeat? You were sent to felony drug court. People who go there are sent there because they have drug issues and they have issues maintaining their sobriety. Why didn't you successfully complete felony drug court? I use. All right. And then what is this about your phone and what was in your phone? About the pictures. Mm-hmm. You know, a lot of times people don't realize that in felony drug court, they do deep dives. You know, sometimes in these courts, we don't have a chance to do a deep dive, like looking in your cell phone, seeing what's going on, but they do. So it appears that maybe you were moving through a phase, but you were not internalizing. So, I mean, you're staring at me. Why did you have this in your phone? A picture of somebody? No, I mean, it's more than pictures. I don't think you want to discuss what you had in your phone because I'm not trying to have people potentially raid your home or anything. But why did you have things in your phone that you were not supposed to have in your phone? Hypothetically, if I had a drug problem and I were in felony drug court, guess what? All the drug paraphernalia that maybe I had, I should get rid of it because I'm supposed to be serious about my sobriety. If there are photos of me using drugs or somebody else using drugs, I would delete that because that's supposed to be my old life. You understand? So why would you have in your phone criminal activity?
Can I have a moment, Your Honor, with my client?
Sure.
Just one moment.
Yeah, don't take pictures of yourself doing criminal acts. I don't think that is legal advice. It's just general advice regarding don't self-snitch.
Oh, Jason. All right, this is what you can
thank you.
return that to probation. This is what the court is going to do. The court is finding violation of condition number 41 true. The court is going to grant the motion, give you credit for any time served. The court will sentence you to 4 years in the prison. And the court will recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Yes. All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed.
He was on probation for drug charges. He then decides after 4.5 years, he decides, hey, you know what? I'm going to do some drugs allegedly. You know what? I'm going to take pictures of myself violating my probation. Yeah, that was not a bright choice, Mr. Now all of a sudden, 4 years in prison for felony drug charge.
Allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. Well, good luck to you when you are released. If you can't find a place where they can help you maintain your sobriety, if I'm still here, you can come back here and I will look for a place that will be beneficial to you. Okay. All right. Thank you.
Yeah. And off he fucks. But that's the thing with drugs. You don't think straight. Yeah.
All right. Who is here? I'm Vanessa Portales.
Yeah. Not only because he did violated his probation, he reoffended. And that's prison. Yeah, he was doing great, to our knowledge. But then he reoffended and took pictures of himself reoffending.
And probation, this is an application. Court is calling let me let you have a seat because probation just stepped out. They should be back in a few minutes. Courtney Sloan. Hi. All right. On this case, where are we on discovery?
Your Honor, the state has produced the discovery.
And state, were you able to tender an offer?
Yes.
All right. How old are you?
43.
All right, Ms. Ferguson, if you'll set this for a plea deadline date in 2 weeks, please. And if you can give the defendant a reset form.
April 7th.
All right, your plea deadline date will be April 7th. On that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, then your next setting will be a jury trial. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you.
What page is Sloan on? Thank you. Is she also Flores? Okay. All right, who is here on Teresa Frias? All right. And where's your client?
Your Honor, do not know about my client's whereabouts at this time. Tried best attempts to contact to remind of court dates, however, to no avail, Your Honor.
All right, court is calling 2024 CR 011807 and 2024 CR 011808, State versus Teresa Frias. Could I have the parties announced for the record? State.
Andrew Harris, Salem.
Defense.
Renee Munoz.
All right, this hearing was scheduled at 9 a.m. It is now 11:44 a.m. Deputy, and your client did not make an announcement. Deputy Laura, did you make an announcement?
Yes, Your Honor, she's up.
All right, defense, have you had any contact with your client?
Not since the last court date, Judge.
All right, state.
In each case, forfeit the bond, issue a warrant.
All right, judge's warrant will be issued. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider, but I'll note for the record that her PR bond was previously reinstated.
Yes, Your Honor.
All right, thank you.
Yeah. We talked about this early on in this stream. There was a kid there who just, hey, he's going to his court appointment, he's doing all of that, and Judge Boyd, yeah, of course I'm going to help you. And here, apparently, we have a person who was reinstated on PR bond and then decided to not show up for the next hearing. Yeah, that will get you into jail fast. I don't know what that person did or didn't do, but all you had to do was to show up. And here we go. Now it's a bench warrant. Now they're out looking for you. And they are going to drag your ass to jail. Yeah. Was it worth it? I don't think so.
Thank you.
All right. Is there anything else on the docket?
Is-
Yep.
All discovery.
Here's the
And
probably
Counsel, you're
last
on this
case.
side.
Thanks, Judge.
You're welcome. Court is calling 2024 CR 0125506, State of Texas versus Vanessa Portales. Can I have parties announced?
Megan Galloway from State.
Ted Wood representing Ms. Portales.
And are you Ms. Portales?
Yes, ma'am.
Thank you for dressing appropriately for court. Counsel, have you received all discovery?
I have, Judge.
Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Portales, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented? Any objection?
None, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with harassment of a public servant. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
I didn't understand.
The rights that I've explained to you, do you understand them?
Yes, ma'am.
Are you intending to give up those rights and enter into a plea bargain agreement?
Yes, ma'am.
All right. Are you sure? She's sure she wants to enter into this plea bargain agreement, counsel?
Judge, I think she may be concerned about the waiver of the constitutional rights that you articulated, but I explained to her that those rights are waived for this proceeding and this proceeding only.
Oh.
So she's not giving up her right for the rest of her life or forever and ever. It's for this proceeding and this proceeding only.
Do you understand?
Yes, ma'am.
All right, counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Portales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
You
I'm
have to
sorry.
say yes.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine.
Ooh.
There's no application for deferred adjudication, and the state recommends community supervision. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Judge. Probation was recommended, I believe, or community supervision for 3 years.
Well, that's a recommendation, but we're just going over what the plea bargain agreement is, which
Very
you all have agreed to.
very
You
well.
understand that?
Yes, ma'am.
All right. And defense, was that the plea?
Yes, Judge.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, community service hours, And also no contact with a resident on Nogalitos Street, San Antonio, Texas, 78225. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
No objections, Judge.
And state, have you spoken with the complainant? Okay, all right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same, and the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
I don't think there was a PSI requested, Judge.
No. So do you wish to proceed?
Yes, Judge.
All right. Anything you wish to say on behalf of your client?
Judge, Ms. Portales and I reviewed the situation and she believes that it's in her best interest. And I agree with her that jury trial is not in her best interest. And the judge, we're just asking that you go along with the 3-year recommendation and give her a chance to rebuild her life.
All right. What do you do for a living?
I'm a Valley Living. I do work for the community apartment complexes.
Okay. And I'm sorry, what do you do?
For Valley Living, I pick up like their trash and stuff and put it in the compactor.
Okay.
I work a part-time job due to that because I do my GED. Right now I'm in GED classes.
Mm-hmm.
I'm studying for a truck driver, so I do work my part-time because of that. Put in my hours at school to make time for that as well.
Okay. And do you have any children?
My children are 23 and over, so.
Do you have grandchildren?
No, not yet.
Okay. And when you say not yet, is there one on the way?
My daughter mentioned she just lost her baby. So.
Oh, I'm so sorry to hear that. All right. So now the big question, why are you spitting on someone? Nobody likes to be spit upon.
I know. To be honest with you, Your Honor, I don't know if I'm able to talk about this to you, but I'm going to tell you, I don't remember what happened to me that night. I do remember when I was sober, one of my old growing up friends that lived down my street, they asked me to take him to the bar. And me being nice, and I haven't seen him for over 50 years.
Did you?
I ended up taking them to the bar and dropping them off at the bar. And they're like, hey, you want to come in so you can.
And did you drink as well?
And I went in there to because I love pool. I've always liked to play pool as a child.
Mm-hmm.
So I went in there and one of the girls that I took that we grew up from our childhood, she offered me a drink from the bartender. But they're like, when I got that drink, I hesitated to get it. But the drink, I believe that it had something in it. After that,
no, here's the thing.
I don't remember.
The problem is that it appears to me that you have issues with your sobriety and you should not have been drinking at all anyway. Let me tell you something, what I know. What I know is that if you are being clean and sober, there may be certain places that you should not go. But if you decide to go, like if a friend, and I use that term loosely, because if it was a friend, they would never have said, hey, let's go to a bar to begin with. But let's say you go to a bar. A friend should not be buying you drinks. And if they are your friend, then they know what your issues are. They know if you're trying to maintain your sobriety, because then we end up here. You understand?
Yes, ma'am.
So that person should probably be removed from your friends list. And they always tell you, you need to change people, places, and things. So sometimes, mainly it's the people. You understand?
And you know what, Judge, I was telling my lawyer that
Oh, shut up, shut
From
up,
my
shut up.
childhood. We grew up in this.
Oh, I told my lawyer, no, 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 no. Don't waive your attorney-client privilege.
Same neighborhood, so I ran into her, seen her, and when she asked me for the ride, I did all that, and I took them. I hadn't seen this person for over 15 years.
And
Now
you
that
know
we're
what?
adults,
Sometimes people are best left in the past.
Work.
Because when you break up with somebody, there's a reason you broke up with them. When you haven't seen a friend in a while, there's a reason why you haven't seen them in a while. So this is what the court is going to do. The court is finding you guilty. The court is going to sentence you to 6 years in the prison, suspended and probated for 4 years. There's regular reporting by Zoom or in person. There's to be regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. I'm going to order 90 sober meetings in 90 days. TAP evaluation out of custody. Follow TAP recommendations. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. There's going to be field visits 1 time per month for 6 months. 200 hours of community service restitution. If you obtain your GED or trade school certification, the community services will be deemed satisfied. So it's up to you whether or not you want to end up picking up trash in the heat of the summer in San Antonio. Probably going to be about 100 and something.
Warmish.
Yeah. So that's up to you.
Thank you, Judge.
There is to be no contact with 2432 Nogalitos. And that's 78225. Probation, is there anything else? All right, I'm not going to order the fine.
Thank you, Judge. Appreciate that.
Is there anything else you need from the court to be successful?
Thank you.
thank you.
All right.
Thank you, ma'am.
And do you need anything else from the court?
May I have a work note?
What, for being here today? What do you mean a work note?
Like just so I can have for my records.
I don't understand what you mean by work note.
Like, I wanted to ask if I can have a letter for when I go back to work that they know that I came here.
Oh, no, I don't do that. That's something you have to get from your attorney.
Okay.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. Good luck to you.
Thank you.
All right. Make sure you stay in contact with your probation officer, because in this court, to be successful, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to court. All right. Thank you.
Thank you, Judge. May I be excused?
Yes, thank you.
And that was the final of the morning docket. And yeah, this last, if we go by what she said, met up with a friend or person she hasn't seen in 15 years, who handed her a drink, and apparently she blacked out. Now, if we go by what she says is correct, are there any chances this was a person she hasn't seen for 15 years because that it was a prankster who liked to, let's get people into trouble? I believe it is felony assault charge, so more than speeding. Because just speeding, I think, is a misdemeanor, so it's probably more than that. So this was the plea bargain. So I would believe that the original charges was more than that. So yeah, I mean, I'm not going to call them friends, but I had people in my youth who thought it was hilarious to spike drinks. And stuff didn't go well. Did they do it to me? No, because they knew I would kick their ass if they tried to. But yeah, but this is back in the 80s, so it's many, many years ago. And those people are no longer in my life. And if you have people like that in your life, it's not worth it, folks. Just because you have been friends since middle school or high school, if they keep doing that kind of crap 10 years later, you have no obligations towards that person. Absolutely zero. Absolutely zero. And you're better off without them. Absolutely better off without them. All right, that was Judge Boyd's court. Now, I do know there was something about the 24th that in a previous Judge Boyd stream, I said, oh, I need to check in on the 24th. That didn't happen this morning. But if it happens on the afternoon, I will check that up with you tomorrow. Okay. Thank you, everybody, for showing up. Thank you for allowing me to do this. Thank you for the thumbs up. Thank you for the subscription. Thank you, Guy. You are over at Rumble. Thank you at YouTube. Thank you over at X. And roughly the same time tomorrow, I hope I can get back to you with what exactly was with the 24th that was so important. All right. Thank you again. Have a good one, and I'll see you in the next stream or video. Bye-bye.